There is a powerhouse document that you need as foundation of your estate plan. The power of attorney is a legal document that lets you appoint someone you trust to make decisions and act on your behalf if you're unable to do so yourself. It's not just for the elderly. Every adult should have one. Life is unpredictable. And without a power of attorney, your family may have to go to court to get authority to help you. Now, there are two main types we'll discuss. Number one is the financial or durable power of attorney. It lets someone manage your money, your property, your financial affairs if you become unable to do so. They can do things like pay your bills, manage bank accounts, handle taxes, or handle real estate matters. Durable means that it continues even if you become incapacitated in some way. For example, if you're in the hospital after an accident, your spouse or trusted agent could pay your mortgage, sign your checks, or handle insurance paperwork. The healthcare power of attorney or healthcare proxy lets you name a trusted person to make medical decisions if you're unable to speak for yourself. It works alongside what some states call a living will or others call an advance directive, which provide written directions or instructions about your medical preferences. For example, if you're unconscious after surgery, your healthcare agent can authorize treatment or follow your written wishes. Family members without one may need to go to court to get guardianship or conservatorship, a stressful, expensive, and time-consuming process. Judges then, not you, decide who will make decisions for you. Even spouses and adult children, in some instances, may be legally powerless to act without one. Your agent, sometimes called an attorney, in fact, should be, number one, trustworthy because they'll have access to finances or control over health decisions. They should be responsible because they may need to act quickly in emergencies, willing to serve. They need to be serious. It's a serious responsibility. Number one, another thing, you don't have to choose the same person for financial and healthcare powers of attorney. Sometimes different people are better suited for each role. Now, here's some common mistakes to avoid. Not having one, number one. Accidents happen at any age. Everyone 18 or older should have a power of attorney. Number two, choosing the wrong person. Pick someone that's reliable, not just the oldest child or the closest relative. Another common mistake is not updating it. If your agent passes away, moves far away, or your relationship changes, you may need to change your power of attorney. Or sometimes people make it too restrictive. If your agent doesn't have enough authority, they may not be able to act when needed. For example, without a power of attorney, Mark had a stroke at 52. He hadn't signed a financial power of attorney. His wife had to go through a costly court process to be appointed guardian or conservator just to access his bank accounts and pay bills that she was not on. With a power of attorney, however, in another example, Angela gave her sister power of attorney. Angela was in a car accident. Her sister was immediately able to step in, handle her finances, talk to doctors until Angela recovered. Now, what are healthcare directives? Healthcare directives are written instructions that explain your preferences if you're ever unable to communicate them to yourselves. They ensure that your doctors and family know exactly what you want. Think of them as your voice in situations where you can't speak. Now, there are types of healthcare directives. Number one is a living will, in some states call them, which states your wishes about life-sustaining treatment if you're terminally ill or permanently unconscious. It covers things like ventilators, feeding tubes, and resuscitation. For example, you might state that if you're in a coma with no hope of recovery, you do not want extraordinary measures to prolong your life. The second type, other states call it an advance directive or a healthcare directive. It's broader than a living will. It can include end-of-life wishes and other treatment preferences. It often combines the living will with a healthcare power of attorney into one document. For example, in many states like Georgia, an advance directive allows you to appoint a healthcare agent and records your medical preferences. Most of them also include a HIPAA authorization, which allows doctors to share your medical information with people you trust. Without this, privacy laws may prevent even family members from accessing updates to your health. So why are they important? Number one, they reduce conflict. Without clear instructions, family members can argue about what you would have wanted. Secondly, they guide doctors. Medical professionals are more confident making decisions when they have your written wishes. They also provide peace of mind. Your loved ones won't be left guessing in stressful situations. For these and many more, please talk to an attorney about getting power of attorneys established, both durable and healthcare, as soon as possible. If you need more information, go to my website, legacy-estate-planning.com, and we'll be glad to set up a consultation, or there's information on the website. We also have a book that explains the basic terms of estate planning available for your purchase and download. Have a great day.